Well, hello there. I'm Jonathan Meddings, the chair of the Darbon-Institute, an organisation dedicated to protecting and promoting everyone's right to bodily integrity and autonomy in Australia and New Zealand. And I'm joined today by Tim Arkell, Secretary and Director of Policy. We're going to be talking to you today about some proposed intersex law reforms in Victoria, Australia, and it's kind of signposting how we think we might be able to build on the model that's been put forward here to protect all children. We've got our contact details down there, so if you do have any questions from today's presentation, please feel free to get in touch. So what we'll be covering today is a bit about what intersex is and isn't, the background leading up to these proposed reforms, more of a detailed overview of what the reforms are, and then really just touching on how we think we can build on these reforms to protect all children. So intersex people have internal and/or external physical sex characteristics that are not exclusively typically male or female. It's important to understand that intersex is a collective term that covers dozens of different variations of sex characteristics, some of which are apparent before or shortly after birth, but many don't become apparent until puberty or adulthood. It's estimated that intersex people are somewhere between 1% and 2% of the population. Also, equally important to understand what intersex is not. Intersex is nothing to do with one's gender identity or sexual orientation. Of course, your gender identity, it's in the name. It relates to how one self-identifies, which could be as a man, a woman, gender fluid, non-binary, genderqueer, and sexual orientation relates to whom one is attracted. So just like non-intersex people, intersex people have a range of different sexual orientations and gender identities. That's not what makes them intersex. What makes people intersex is their physical sex characteristics, not being typically male or female. So you can see the background here leading up to these proposed reforms in Victoria. In 2013, there was a Senate inquiry into involuntary or coerced sterilisation of intersex people in Australia. That put out a number of recommendations. Not a lot happened though. Then in 2018, we had the Australian Human Rights Commission launch its own inquiry. That finally reported in October 2021. And prior to that report being released, we had the Australian Capital Territory government make a formal commitment to develop a plan for managing deferrable intersex medical variations. And the Victorian government followed suit and made the same commitment. And then its Commissioner for LGBTIQ plus communities commissioned a group called Equality Australia to conduct a consultation and make recommendations to the Victorian government about how best to meet that commitment. Before I move on, actually, it's probably worth noting here on the background that prior even to 2013, for a very long time, two groups have done a lot of work to advocate for the rights of intersex people in Australia. They are Intersex Human Rights Australia and Intersex Peer Support Australia. And their work, of course, continues. And I would encourage any intersex Australians or their families watching to reach out and engage with these organisations. They're there to support you. So here is the overview of the proposed intersex reforms. This is taken from the Equality Australia consultation paper that was put out. You can see that the goal really is to end unnecessary medical procedures that alter the sex characteristics, that alter the bodies of intersex people without their personal consent. And as part of that, it involves the establishment of an independent oversight body that will include people with lived experience, so people who are intersex themselves. It will also involve the provision of fair and accurate information to intersex people and their families. It will involve the provision of affirming peer support. It will address stigma and discrimination through public education initiatives, and also provide an avenue for redress for the injustices of the past. And again, taken from the Equality Australia consultation paper, you can see a diagram here that outlines the scheme that's being proposed. I want to emphasise it's still very much a proposal. This hasn't been legislated yet although we do hope to see a bill forthcoming hopefully this year. You can see that broadly this scheme involves both criminal prohibitions and civil protections, that the oversight body, we'll talk a bit about its composition, its functions, processes, decision-making principles, individual care plans, and proposed class exemptions. You'll also note that there's a view to nationalise this scheme. So even though it's being put forward by one state in Australia, namely Victoria, the idea is that other states and territories will adopt the same scheme. And there's also a statutory review that would be built in, which is quite common when you're dealing with a quite new, novel, innovative policy reform like this one, where after a set time you want to go back and check that you're heading in the right direction and that things are working as intended. So I'll hand over now to Tim to talk a bit more about the legal aspects of the proposed scheme. Over to you, Tim.
Thanks, Jonathan. I guess the easiest way to put forward this idea is that it's a hybrid scheme. It's a hybrid put forward by Equality Australia, and it's a hybrid scheme that involves criminal prohibitions and civil protections. So the idea being that the criminal involves convictions and criminal sanctions like imprisonment and records that go against your good name. And the civil protections involve fines and administrative sanctions, but also some civil remedies that might enable persons to avail themselves of some civil redress. So, but essentially, education programs that can help move people involved in the protections and treatment of people forward in a positive direction. So the idea being that criminal prohibitions send a strong signal, but they're not totally effective. And the problem is that every Australian state and territory has had criminal laws against female genital mutilation for decades. Yet in Australia, we've had only one successful prosecution in the last 20 or 30 years. And that was late last year in Western Australia, and it really only hinged on a guilty plea by the parties that were involved. And it's been really, really difficult to secure a criminal conviction, even though female genital mutilation has been criminalised in some jurisdictions now for nearly 40 years. So it reinforces how difficult it is in the criminalisation of these procedures. The civil mechanisms really provide victim survivors with a more accessible legal recourse, I guess, for the wrong that they've suffered. Often, most survivors of harmful body modifications, they're not really wanting, for most people, their parents have consented to a procedure, and their parents have probably consented to a procedure on the basis of good advice that they, or what they thought was good advice at the time, so that they're not wanting to really um, persecute their parents or whatever, but they're more wanting to lead to a process that might lead to a healing of how they feel and as a victim survivor of these body modifications. The criminal sanctions provide that there are two offences here, and these are the two offences proposed. Remember, this is a model put forward by Equality Australia. This has not been passed into legislation yet, but this is a model being put forward by Equality Australia, who've been engaged by the Victorian government to come up with some ideas. And their ideas is that it's a hybrid between criminal and civil sanctions. And the criminal sanctions involve two concepts. One is a personal offence. It's an offence by the person who has provided medical treatment to modify the sex characteristics of another person. And you can see that we've got bolded here, we've got bolded words and italicized words, and they have defined definitions in the index that we provide at the end of these slides that will give you more ideas of what these words mean. But essentially, it's medical treatment to modify the sex characteristics of another person, but that person needs to be a protected person, and it needs to involve a procedure that occurs without that person's personal consent. So that's one offence. And then the other offence is by third persons, I guess, by persons who assist or procure the treatment, the medical treatment to modify the sex characteristics of another person without that person's consent. That person is a protected person, and they remove that person from the jurisdiction of Victoria. Now, Victoria is a state of Australia. Australia has a number of states and territories. So we have different laws in states and territories. So this is confined to Victoria. So the idea is that the first offence is a personal offence. It's you did a procedure against a protected person to modify their sex characteristics. The other one is that you procured another person to carry out a medical procedure to modify the sex characteristics of a protected person without their personal consent. So the idea here is that it's to provide that there is no defence. Often the defence used by parents is that they've consented to a procedure on a minor. A person here in Australia, a minor is considered a person under 18 years of age, so that the parent is able to give consent to medical procedures against a minor. So the idea here is that that idea of parental consent is removed as a defence to a procedure that modifies a protected person's sex characteristics, so that the person providing the medical treatment cannot rely on the parental consent defence. Okay. Now, there's a few difficulties that are created by other legislation, such as the Limitation of Actions Act in Victoria, which provides that if something has occurred at a particular period of time, you've got a defined period of time in which you can take action, either criminally or civilly, against that person. It's generally civil. It's generally not criminal, and the idea is that they need to remove that restriction that the Limitation of Actions provides. I don't know what that is. I don't practice in Victoria. I practice in another state of Australia, but it's generally around about the 7 year mark, I think, in most instances. All right. So the consequences of a breach. What happens if a person does subject a person to these treatments without the person's personal consent, or without being in some other defined category, which will become evident later? So a person who has been subjected to treatment without their personal consent will be able to sue. I don't know what some persons listening here on this, because this is a worldwide presentation, some of you will be conversant with the English concepts of which Australian law is based upon the law of torts. They're able to sue in actions such as assault and battery and negligence, which are tortious actions. I describe them for the non-legal person as a civil remedy, a civil wrong. And they usually provide a remedy for compensation, monetary compensation. And the idea being that they can receive this monetary compensation notwithstanding that their parent might have provided consent to their treatment, and notwithstanding that I just said in the previous slide that consent is invalid. The other repercussions to the medical practitioner that carries out these procedures is they are subject to restrictive they're subject to prohibitions and regulation by a number of authorities here in Australia. The first one is APRA, the Australian Prudential. Sorry, I can't even remember its name now. I'm put under the pressure. It's an organisation that regulates persons who are carrying out medical procedures, including doctors and nurses and other medical professionals such as chiropractors and other persons. It also, a lot of those practitioners will be members of medical bodies such as the Royal Australian College of Physicians or the Royal Australian College of Surgeons or the Urological Society, USANZ it's called, or something. So a lot of those professional bodies have their own methods of regulating their members. And some of those actions, if you undertake a procedure that's not authorised or not consented to, then it can lead to some serious disciplinary action that can result in your loss of registration and your right to practice as a medical practitioner in this country. It could result in a public reprimand, or it could result in some sort of restriction on your right to practice without supervision. So there are serious consequences. APRA, the Australian Health Practitioners Regulatory Authority, there you go. It results in some serious repercussions, not only financially, but also in consequences for your right to practice either ultimately or without restriction. So the idea being that it creates an oversight panel, and the oversight panel will help intersex people and their families and health professionals providing treatment to those persons to prepare and register what we call an individual care plan, and that's also defined in our glossary at the end. And the idea being that it makes orders to allow for the provision of certain treatments that may benefit intersex people without the need for an individual care plan, but subject to certain safeguards. So therefore, it helps people that can come up with a care plan, but it also helps people come up with a care plan that for those persons that mightn't be able to have input to coming up with a care plan, but with certain safeguards. So the idea being that the individual care plan can allow a medical treatment that modifies a person's sex characteristics without their consent, but only when that treatment can be deferred without being likely to cause harm. So in other words, if the treatment is deferrable, in other words, it's not life-threatening or otherwise needed to preserve the sanctity of life or make life better for the person in the eyes of the medical practitioner, then the treatment should be deferred. So the oversight panel will operate along the basis that the chair or the chief officer of the oversight panel is someone with some background in law. So they'll either be a senior lawyer with background in these particular areas, or they'll be a former judge. And then the other parts of the panel will be made up of what we call lay panel, lay persons rather than persons with legal knowledge. And there'll be persons from drawn from the community of persons with innate variations of sex characteristics or their families. There'll be 3 health professionals, and then there are another 3 drawn from 2 bioethicists and a human rights specialist. Now, that could be a lawyer or it could be a lay person with human rights specialty. And the idea of it being that an interested person can apply to the oversight body for the preparation and registration of an individual care plan in respect of a protected person, if the treatment, medical treatment that is, if the treatment is proposed to modify that person's sex characteristics. So There's a number, as I said before, those bold and italicized words are defined. So there's clear definitions here of the persons that are involved in either the treatment or undergoing the treatment or able to provide consent to that treatment. And then there are substantial protections that would limit the oversight body's decision-making capabilities such that they're not able to make decisions on behalf of persons who can make those decisions for themselves, or for treatments that can be deferred without causing harm to the health of that person. So the idea being that the protected person, the persons with these intersex characteristics that fit within the protected person definition of the legislation, if they're able to make those decisions for themselves, or that treatment that is proposed can be deferred without causing harm to the health of that person, then the oversight body has no authority. And the other thing is that there are procedural protections which include requirements on the oversight body to ensure that the persons that are not able to give legal consent. So I don't know how many of you understand Gillick competency, but Australia being a former English jurisdiction also understands the concepts of Gillick competency, which comes from an English decision of the courts. And it basically says that a person of about 13 or 14 years of age or thereabouts tends to have enough cognitive ability to be able to understand the implications of the procedure, and generally speaking can give consent to those procedures. So a person under that age might be considered not to be able to understand, but their views nonetheless are important. So the oversight body needs to be able to understand that they are able to hear the views of persons that may not be otherwise Gillick competent, but they are able to express their views in such a way that the oversight body can't override those views from an objective point of view. So this is very much a subjective concept. And Jonathan, you might be able to expand on me a little bit more here, because you seem to understand this protection a little bit better than I do.
Yeah, so the two procedural protections, Tim's spoken to the first one there around the oversight body and people who cannot give legal consent, nonetheless being given reasonable support to express their views. The second one is that its decision-making is not discriminatory by prohibiting the oversight body making presumptions without any substantial evidence that a person would experience a social or psychosocial benefit from having their sex characteristics altered. And this is a really fundamental part of the proposed scheme, because we know that one of the main arguments advanced for sex reassignment procedures on intersex minors is that there'll be some kind of psychosocial benefit from them being anatomically clearly a boy or a girl. And it's just not the case that that's supported by medical evidence. It's really not. So this is another key procedural protection which will have the effect of preventing sex reassignment procedures on intersex minors.
All right, thanks, Jonathan. The model proposed by Equality Australia contains a proposal for the adoption of the scheme that's a Victorian scheme, as I've outlined before. This is a model proposed by the Victorian government, and they've asked Equality Australia to provide their assistance and feedback and ideas on how they might implement a model to protect intersex people in Victoria. And the idea being that this model may be rolled out across other jurisdictions in Australia. For those of you listening from overseas, Australia is a federation. It's a loose association of states that have given up certain rights to the Commonwealth or the federal government, but it retains other rights limited to the states only. And so the idea being that the scheme proposed by Equality Australia would allow for adoption of the Victorian scheme by other states of Australia, and it would authorise the Victorian Minister for Health to approve the adoption of their scheme by other states and territories by opting into that scheme.
Yeah. It's a good point, and hopefully we can nationalise this scheme and prevent people being subject to these procedures, not just in Victoria, but in every state and territory in Australia. But in the interim, of course, you'll recall the two criminal offences that are being proposed. That second criminal offence will, until every other state and territory adopts the scheme, prevent people being taken out of Victoria to be subject to these procedures. So that's a good thing. Just wanting to wrap up with the proposed exceptions that are being put forward to this prohibition. You can see that the last three here are pretty non-controversial. We already have a legal understanding of medical emergencies where consent is overridden because we're talking about life-saving procedures. The individual care plans that Tim has discussed that will be registered with the oversight body, they check all the boxes and really ensure that people are being helped, not harmed. So they're a great thing. And then the class exemption order, that's really just a way for the oversight body to respond to the complexity of different intersex variations as it implements these reforms without the need to go back and change the law again. So again, very sensible. I don't need to tell this audience, though, that the glaring problem with these proposed exceptions is the first broad exception for male circumcision. This has been put forward really because policymakers don't want to see these reforms derailed by a debate over male circumcision. And it's resulted in the quite odd situation where we have reforms being proposed to prohibit non-consensual medically deferrable alterations of sex characteristics of intersex minors, except for one particular kind of non-consensual medically deferrable alteration of sex characteristics in the form of circumcision of the penis of intersex minors. So where to from here? Well, the Darwin Institute is developing a white paper outlining options to build on these world-leading reforms. They really are world-leading, and the Darwin Institute supports them. There's certainly progress for intersex people, and they should be welcomed. But as part of our white paper, we're going to be considering the potential to expand the scope of protected persons to include all people, regardless of their sex characteristics. So in other words, intersex people would not be the only protected persons. It would also include non-intersex people, essentially everyone. We're going to consider narrowing or even possibly removing the exception for male circumcision. So you could imagine, for example, that exception being narrowed to religious circumcision of the penis. In a country like Australia, where the vast majority of these of male circumcisions are performed for social and conformist reasons, such a narrow exception would still protect the vast majority of boys, which could be viewed as progress of a kind. And we're also going to consider whether or not a similar oversight body for endosex, or in other words, non-intersex people, would be beneficial as part of such an expansion of this scheme. The goal really being a harmonised and legislative and regulatory approach to non-consensual medically deferrable alterations of sex characteristics, regardless of sex or gender, so that all children are protected from these harmful procedures. So here is that list, that glossary of proposed legal definitions as promised. I do highly recommend reading the Equality Australia consultation paper. It obviously goes into much more detail than we've had time to go into here, but these definitions again are taken from that. Some references if you'd like to look them up. These are some of the things we've spoken to tonight, and this is just some information about the Darbon Institute for you. As I said at the start, we're working towards a world where the right to bodily integrity and autonomy is respected, protected, and promoted for everyone. We hope that you will join us in this fight. We welcome members from right around the world. You don't have to be based in Australia or New Zealand. We also welcome donations, which you can make through our website. So on that note, I'll hand over to Tim to say any final words. Tim?
Yeah, thanks, Jonathan. Look, I'd just like to extend a thank you on behalf of the Darbon-Institute and the board to Victor and Christoph and the MOGAS organisation for putting the effort behind WWDOGA 2022. We are saddened that we can't join you personally. There are restrictions placed upon us in events that are placed upon all of us in being able to travel, and it's difficult at the moment. But we certainly are grateful for being able to be part of the 2022 WWDOGA presentation, and in respecting and understanding that we're at the 10th anniversary of the Cologne decision. So thank you, MOGAS, very much for allowing us to be part of your presentation.